No, I had the ticket and I had
You're going to take a look? And yes.
Thank you.
No.
Strange. Thank you.
All right. So we're going to call case 14 TRD 01187. That is the charge of a stop sign violation and no seatbelt on April 5th, 2014. Looks like this was at 6th and 133rd in that area. Insurance was shown. Is that correct, Counselor?
Yes, Your Honor.
What we may want to do, if Mr. Jackson has his insurance on you, I can update the file because the ticket seems to mark both boxes. And what may happen is the BMV could give you a suspension, but you could show that to me now, or you could show it to the clerk's office when you're done. Either way.
We might not have it on email.
Okay.
Show you maybe we can take care of it
At the clerk's window? All right. So in this particular case, it looks like the stop sign was going to be amended to unsafe motor vehicle, which carries no points, and the remaining charge is going to be nollied. Is that your understanding?
It is.
So, Counselor, to the charge of unsafe motor vehicle, I'll accept the no contest plea with the finding of guilt. The fine is $100 plus cost. The other charge is nollied pursuant to the agreement with the city. And then we have case 14 CRB 00405. That's improperly handling of a firearm. For today, we acknowledge that, Counselor, you sent in your plea of not guilty initially. But after conversating with the city prosecutor, it looks like there's a resolution. Ms. Hemmings, could you state what the city is willing to do?
Your Honor, we're going to recommend that the first offenders program be utilized in this situation. That we agreed to the terms and conditions of conversion, which is Attorney Weintraub has explained to him. And other than that, this matter is concluded as far as we're concerned. We think we're trying to successful completion of the conversion.
Okay. All right, and Counselor, that's your client's desire?
Yes, it is.
Okay. So what we'll do to the charge of improperly handling a firearm in a motor vehicle, we'll accept the plea today. We'll hold a finding in advance, and basically that's giving you a chance to go through the first offenders program. Technically, we've renamed it the Cycle Breaker Program. Bottom line is that we want to make sure we're breaking negative cycles in our community, whether that's improperly handling a firearm, assaults, domestic violence, whatever the case may be. So it's a great program, and it gives you an opportunity to move forward without this on your record. And I'm sure your lawyer will let you know, though, if you don't comply with the terms and conditions, then all bets are off as far as how it will turn out at the end, meaning you'll have a record and you'll have to deal with the sentencing that would be a lot different than what you'll get at this point. You understand all that? So what I'm going to do, and also it's important to know, Mr. Jackson, normally with the improperly handling of a firearm, the policy that I have now in East Cleveland is that if there's a gun involved in any of the charges, there's mandatory jail time. But after discussing this with your lawyer and the city prosecutor, what we're going to do is modify yours in the sense that you're going to be on probation, you're still in the first offenders program, and we're going to allow you to schedule the jail time around your working hours. And we've had specific discussions in regard to that, so I'm going to make notations here. So we're looking at a weekend for you, all right? If there's anything else that you don't understand, the probation department will explain it to you, and I'll make sure there's pure clarity on everything, all right? So to the charge of improperly handling a firearm in a motor vehicle in violation of East Cleveland Code 54904, how do you plead?
No contest.
Thank you very much, Counselor. I will accept the no contest plea. The finding will be held in advance. We're going to have him report to probation. So May 19th at 9:30 is your reporting date. As I indicated to your counsel, you don't need his services for that purpose. It'll be simply telling you what to do for the program. I imagine I won't have to see counsel unless there's some hiccup in the process. Part of the program will be you attending the Finish First program we do here, which is talking about how to avoid negative interaction with the legal system, and some other things we're going to have you do in that regard. All right? Any questions? Last order of business, counsel, I know I mentioned to you the fee for the first offenders program is, I believe Ms. Johnson's $300, correct? $300, but that covers your court costs as well as the fine, well, as well as the fee. All right? All right.
Thank you very much.
Thank you very much. Appreciate you, and we'll see you very soon, sir. You have your reminder for the May 19th? Or is it at the back? Okay. Take care. City of East Cleveland versus Cal Dombrowski. How are you, sir? Good. It looks like what I have here is case 12 TRD 05125. And that was a charge of driving under suspension and providing false information that occurred back in October of 2012. How are you doing today? Good. It looks like there was some information provided to the court in regard to why you were unavailable, and I guess where you had been for the last few months. So what I'm going to do, unless there's an objection from the city prosecutor with this 2012 case, we could resolve it today with a resolution in regard to the driving under suspension, Ms. Hemmings, but based on Mr. Dombrowski's term of unavailability for a while. If the city is willing to dismiss that other charge dealing with the falsification, the court would have no objection to that.
No problem, Your Honor.
Okay. So, Mr. Dombrowski, you understand what's happening? What I'm going to do, basically, you have two charges: the driving under suspension and then providing false information. The driving under suspension, it looks like you're in a position where we can at least get that case resolved. You have insurance. The providing false information, because you were unavailable, you had gone through the process of being in prison, and then you're now getting back on your feet. What I'm going to do is acknowledge that you've done all that stuff after this case occurred. So what I try to do, just so you know, is when I see that young men like yourself are trying to get back on the right track, you made a mistake, but you're moving in the right direction. I don't have a problem of lifting the burden of having to deal with that old case dealing with the falsification, because my hope is that you've learned from that experience, considering everything else that you've been through. So we're going to dismiss that with the city's understanding, and all we're going to deal with today is the driving under suspension. All right? And part of that is because you did have people who submitted the correct motions and everything on your behalf. So that was a good thing. They took care of business for you properly. So to the charge of driving under suspension, on October 2nd, 2012. How do you plead? Okay, I'll accept that no contest plea with the finding of guilt. That fine is $350 plus costs. The remaining charge is dismissed. I do see you have insurance. So at this point, you go to the clerk's window. They'll make the application there, and good luck going forward. All right, take care, sir. City of East Cleveland versus Robert Jackson. Mr. Jackson is 13 TRC 03451. Good morning, sir. How are you? Good. Okay, Miss Ivory, are you familiar with Miss case? Okay. Mr. Jackson, basically, just to come up to speed, it looks like this was an OVI that we had resolved. Okay, and it looks like you were transferred to the county. Right. Because yeah, and I think that was my intention with this one.
Closes probation.
Well, this guy multiple sentences. Oh, but I did with him. So see here, I put here, I was check to see who's a 15, moving 14. Interesting, he was at least on November 14th. No. That's what I asked myself. So this is what I'm going to do. I'm going to go to step. Did not tell me that this was I was
Just trying to get probation. Who's he signed to? Oh,
He
yeah.
never
Yeah,
sent
we
us.
can just tell him. Just give him the report.
Right. And we'll do the record. Okay.
Okay.
We'll do the record. Okay, this is what I'm going to do, Mr. Jackson. If you recall, on a previous occasion, you entered a plea of no contest to the OVI. Remember that? And with that, there are certain ways we have to get the case resolved. One of those is there's always mandatory jail time. There's a mandatory drug and alcohol assessment in AA classes. Your case is a little unique in that when you were here, I knew that you were being transferred to the county. So I made a note here. I set your sentencing date, the date for you to come back, for November 14th, 2013. From what I see here, you were released from the county on November 14th, 2013. But then what I understand, and it makes sense to me, because when you're standing here locked up and you go to the county and all those dynamics, you may not quite understand exactly what I mean. What I put here is that I was going to hold off and have you come back when you're done with the county situation. You may have thought that you did not have to come back, because my expectation would have been that day you were released on the 14th, if you couldn't come back that day, that you would have come back the next day and said, hey, Judge, I'm out. Let's get this case resolved. You didn't do that, but I understand that there was a misunderstanding, because then you did come and talk to our bailiffs and they explained what was going on. So what I'm going to do is resolve the case as we stand here today. The no contest plea, there's a finding of guilt. The fine is going to be $300 plus cost. There will be 180 days in jail, but I'm going to suspend 150 and give you credit for the time that you were in jail from the moment you left here to November 14th. So I'm going to state that you've satisfied any jail time. Your license would be suspended for the minimum of 6 months. That would have been starting in September. So technically your suspension is up at this point. But I am going to put you on probation so that we can get this alcohol and drug assessment as well as the AA classes complete. Once we do all that, Mr. Jackson, you're really on the going around third stretch to finishing everything. So it's not even at the beginning for you. It's just a matter of going to probation, doing the assessment and the AA classes, and then we should be done. Any questions you have? All right. So we're going to give you a date. It's going to be May 19th at 10:30. That's when you'll come through the front door, down the stairs to your left to probation. All right. Good luck, sir. Yeah, what I'll do is I'll make sure that there is no current warrant block or anything on you. So you should be fine in that regard. All right. Take care. You too. The City of East Cleveland versus Barbara Williams. Ms. Williams, we have case 13 TRD 01957. That was a driving under suspension. How are you today? Good. Let me see what else was on that ticket. It looks like that was driving under suspension on May 14th of 2013. And then there was 11 TRD 06192, expired plates or improper plates, and that was on September 28, 2011. You did show insurance on that one. Let me see if you showed it. You showed it both times. So you're ready to get the case resolved, correct? From what I see here, it looks like after you spoke with the prosecutor on the 13 TRD 01957, that's going to be amended to failing to display your license. The benefit is you don't get any points or suspension. Ms. Simmons, I see you're rising.
Yes, we always have.
Okay. So what's your plan in regard to, have you gotten your Ohio license yet, or? Okay. You don't like Ohio? All right.
If you're in Ohio for more than 6 months, you're supposed to get an Ohio license, unless you're full-time student.
Okay. What are you taking up at that case?
I do it my social work and
Okay. Ohio may need you. All right, well, let's do this. On the 11 TRD, let me start with that one, 06192, it looks like the city has agreed to dismiss that at cost, correct? And that's your agreement, Ms. Williams?
Yes.
So we'll do a cost only on that one. So, Ms. Williams, you used to live in Ohio, though? Okay.
I did my undergraduate in North Carolina, and that's where
Okay. All right, so this is what we'll do. The failing to display doesn't have any points. You still want to enter a plea of no contest, correct? Okay, I will accept that with the finding of guilt. The fine is $250 plus cost. However, with you being a student here at the wonderful school or case, you know, social work and political science and all that stuff, I'm going to acknowledge that. And plus, from what I understand, there's nothing wrong or invalid with your regular license. It's just a matter of whether or not you're going to be here. Actually suspend $200 of the $250 fine. So it'll be $50 plus costs. All right, you go to the clerk's window. Have a good day. You're welcome. Quentin Miller. Mr. Miller is 14 CRB 00509. Mr. Miller is charged with criminal trespass, okay. You know what, Mr. Miller, what I'd like to do, I know we had put this off, and I even made a record of what the city's concerns are. You know, the city is concerned, obviously, that you continue to get these trespassing charges. You did come to the program on Monday. Do you remember what the program this Monday coming up is about? All right, so being ready, job readiness, right? You know, how to prepare for interviews and get a good job, resumes, time to tie, all that good stuff. Mr. Miller, what I'm going to do, Ms. Simmons, because he did appear as I asked him to do, what I want to do for Mr. Miller is I'm going to continue this case. Because my major concern, Mr. Miller, is to see you moving in the right direction. And as long as I can do that, and then eventually we're going to get this case resolved. But I want to see some results, some positive results, Ms. Simmons. So we have a plan for Mr. Miller. And he did a good job with, you know, participating and showing up on time for the program. So how you feeling? Okay. So this is what I'm going to do, Mr. Miller. I'm going to see you next week. And a matter of fact, what we'll do, we have that session on the 19th, but then the 26th we don't have a session. That day is a holiday, court is closed, but we're back in June. You know, it's Mondays at 5:30. So what I'd like to do, I'm going to put down here that I'm going to see you May 19th, which is this Monday coming up. I'm going to see you June 2nd, and then June 9th, and June 16th. Then you'll come back to court on June 19th, and we'll get everything resolved. All right? So I'm going to write all that down. Ms. Simmons? I guess I need a second. I thought you were rising to speak again.
Oh, no.
And let me write this for So June 19th is when you're going to come back to court at 9:30 a.m. And the classes are going to be here in the courtroom. May 19th, June 2nd, June 9th, and June 16th. Any questions? I'll see you then. You're welcome. Anything pressing and everything is just wrong. Nothing that needs to go. No. Okay. Mark Hayerton, 14 TRD 01587. Good morning, sir. Good. We have a speeding violation in window tint on April 16th. It looks like you spoke with the city prosecutor and she's willing to amend that to unsafe motor vehicles so that you don't get any points, and the tint was going to be dismissed. Is that your understanding? Okay. Do you have your insurance information on you? Okay. All right, well, what I'd like you to do, just to protect you, you know, obviously when you get the case resolved, there are going to be fines and costs. If you could bring it up here or fax it up here within 72 hours, because I don't want anything to happen. It's not marked on the ticket. It wasn't put in the file, so I don't want the B&B to suspend you. Okay. No, it would have to either this one, or if you could just bring it up or fax it to us and we'll write it down. So how do you plead to the amended charge of unsafe motor vehicle? I'll accept that. The fine is $100 plus cost. I'm going to put here 72 hours to produce your insurance. Please go to the clerk's window. Thank you very much. Yeah, you just go right up to the window, and if it's not Ms. Henry, all right. Thank you, sir. The City of East Cleveland versus Sir Christian Williams, 14 TRD 01521. This is an allegation of driving without a license on April 17th, Superior Avenue area. No insurance was shown. Mr. Williams, how are you today? Good. Mr. Williams, it looks like you are requesting the opportunity to get your license. Is that correct? All right. Yeah, June 18th is the next Wednesday. Yeah. All right, what I'm going to do, Mr. Williams, is set this for June 18th. I'll set it for 9:30. Keep in mind that not only do we need you to have your license, but you have to have insurance also, because otherwise you'll get the license and then you'll get suspended. So I'll see you back. We'll give you a reminder for June 18th. Right there, June 18th at 1:30. It's right in front of you, that reminder. Instead of 9:30, it'll be 1:30. All right, we'll see you then. You're welcome. We can. I wish you didn't have to sit here. Are they felonies? It's two. Okay. Or you know what I'll do? As soon as she finishes that out here, let me do it. That way you can know like felony differences. Okay. The City of East Cleveland versus Ebony James. Good morning, Ms. James.
Good morning.
Okay, we have 13 TRD 03742. This is a driving under suspension, as well as driving down the improper street. It looks like you're now ready to get your case resolved, correct?
Correct.
With the status of your license, we're able to amend your charge from the driving under suspension, which carried points in the suspension, to failing to display, and it looks like the city's willing to nolly, which is dismiss that other charge. Is that your understanding?
Yes.
So to the amended charge of failing to display your license, how do you plead?
No contest.
I'll accept the no contest plea with the finding of guilt. The fine is $250 plus cost. Did you show your insurance information?
Yes.
Oh, yep, I see it right here. Let me. Okay. Ms. James, it's my understanding you actually entered the diversion program, which allowed you to work on getting your license, so congratulations. And
Thank you.
congratulations. Thank you, Bailiff Sanders. So what we're going to do is suspend $150 of that.
Okay.
So you go to the person to handle that. Let me get this other case resolved. 09 TRD 00569. That was a red light. The seatbelt. Did you get that case? That's an old case. Do you still owe anything on that?
I came and paid $450 last week, and I still owe $100.
You remember that case?
Yes, I do.
You remember who your attorney was? No. I was your defense attorney on that one.
You should have helped me.
What? We have to talk about that later. Right. Yeah, I just suspended fines and costs, but I'm not going to hold you in contempt. All right, so you're done. You just go to the first one. Take care. Make sure you remain orderly. Continuous in this, right? So they both can be separate. All right. Okay, City of East Cleveland versus Earl Wilson Jr. That's case 14 CRB 00523. Mr. Wilson, how are you today? All right, Mr. Wilson, it looks like on this assault charge, which you already entered a plea of not guilty, you are now requesting a trial, correct? Okay. This is a CRB case. Is it for the city in regard to a trial for Mr. Earl Wilson? We need a trial date. Okay. Criminal assault. So we're going to set the trial date June 5th at 9:30. All right? We'll give you a reminder for that, June 5th at 9:30. And then the other cases, which are the traffic cases, we understand that you're trying to get your license, so I'm going to reset those for June 18th at 1:30. So that's case 14 TRD 01708, 14 TRD 01729, and 14 TRD 01730. Those will be set for June 18th to give you a chance to try and work on your license. You understand everything? All right, Mr. Wilson, I know you know about the programs we do. So what I'm going to do is expect you to continue with the programs while we're continuing these cases, all right? So we'll see you on Mondays at 5:30. Any questions? All right, we'll see you soon. Let me see. So we're ready for the founders.
Yeah. She called, she kept calling his name, and he didn't say anything. Are you calling? Kept calling his name, he didn't say anything, he just sat there.
So, Mr. Collins, you didn't get a chance to speak with the defense attorney? All right, we'll give you the opportunity. As a matter of fact, what I'll do is when I finish this, I'll read. All right, so this should be continue. You don't have it, but I'll just tell you. Well, it's all right. What's going on with you? That's really set. It was, I think we just got in 2 days ago. Okay, 13. So, looking at yeah, wait a second. And that is a yeah, F1, so these that's no up again. Put on this and stuff. So you have should that's a mess of violence sometimes too. That's like who has how has the time? Yeah, she got the ball. No, you need headings. That's it. This is for time, right? He's a jail, right? This one. Did she talk to Shelly Oliver? So it's open straight. I see like not guilty. Stephen Boothville, not guilty. Kevin Lane. All right. Steve Easton versus Shelly Oliver. So there's nothing else on this side. Is it? Is that right? No, I'm moving. Yeah. Not far. Yes, sir. What's your name? So DV. Yeah, I got him. It's missing. Ms. Simmons and Ms. Black?
And here's the,
Well, I'm not handling that one yet.
oh, for Mr. Oliver,
Yes.
see the gun, the young son pulled a gun out, but the police let him go because he said it was in defense of his mom. But the young son pulled the gun out because he was beating his mother.
What would have happened if instead of done something with it?
Okay.
That concerns the mother. She spent more than an hour and a half with her to that. And she had things in place. Because when we start talking about, I want to
Okay.
she's coming in with that. And I don't want to put she had depression.
She hasn't been here.
She said,
You should. I'm just.
that is the first. Start feeling a lot of emotional burden. Another one is he works. He's a worker.
You should okay. Come
She don't want to come back.
She should be divorced. That's his wife.
Yeah.
Are they going to be divorced?
She don't know if he'll be willing to do anything. I told her to get this kid so I can things in her. She can do some things. The son is. So her and the son are both prepared to move on because the house is too big for her. Expensive.
So she don't know. Does he have enough place to go?
I don't know.
Okay.
Because he drinks. He drinks on a daily basis.
Is she willing to come in for it?
Well,
because I'm
the
thinking
reason
about
she-
having both these come back Monday.
Okay, the reason she didn't come in today is because she had 11 o'clock appointment to call. About the time we might be, but she knew she couldn't. She came in and we were. The woman doesn't want to. No. This is the one with the son put the gun out. And shooting. This is on this level.
Let's see. I was going to give him.
She's not the son.
She's in
Another thing, she said that this has been talked about food and the kids. Time to time is a time. So she said that if he wants to come in, she said that surely we can go help with this and his son will go to do it. So she's not, she said she's not prepared without him doing anything or taking something. So she won't prepare. He wants to do it like a church. That's what I told her. But she's not going to do anything.
So, what about Kevin Burke?
I got that over here.
Struck his girlfriend in the mouth. Struck his girlfriend in the mouth with a clothes piece.
I wish somebody was there.
What's the allegation against the person?
That he struck his girlfriend in the mouth with a clothes piece. Strapped him. He was going to hit her in the mouth. And he was going to enter a plea of no contest. Both of these guys want to please with her.
She has a call this 614 614 number, and I tried to call her. I saw them. So it wasn't able to.
Okay, so, all right. The Henry, he's pleading not guilty. Set up arms. Yep, I just realized that not guilty set up arms. We set for Monday.
Yeah.
Okay.
I'm trying to
Yeah,
get here.
no, she was in here. She had a job.
Thank you. All right, gentlemen, thank you for your patience. Both of you, and I'm going to deal with you individually, but both of you are charged with domestic violences. And there may be some others charged with domestic violence. The reason that's important to distinguish a domestic violence charge is because the first time that you plead or are convicted of one, it's a misdemeanor. The very next time it becomes a felony. So that's why it's important that you talk with the defense attorney and make up your mind how you want to proceed, because they have ramifications later on down the line. It's not just a matter of you want to get out of jail today, so you want to enter a plea. You have to look further down the line, because once you start getting these on your record, it multiplies the situation as far as jail time as well as your fines. You understand that? So I'm going to deal with Mr. Oliver. 14 CRB 00541. Mr. Oliver, your charge is domestic violence, which is a misdemeanor of the first degree, punishable by up to a $1,000 fine and 6 months in jail. The allegation is that you shoved your wife to the floor during an argument. All right. So what we're going to end up doing with that not guilty plea is set this for a trial. Also, because there is a domestic violence and I know limited information about what happened, there's going to be a no contact order. So two things will happen. I'll set a trial date, I will set a bond, but then I'm going to enter the no contact order, which means you have to have another place to go. Do you have another place where you can go and reside? I'm not sure what your resources are, but definitely you cannot go back to this home. If you do that, that could be a separate violation, which could mean 6 months in jail and a $1,000 fine all by itself, at least. Okay. So you still want to enter a plea of not guilty at this time, correct? Are you working currently?
Yeah, I might have lost my job.
I'm going to set your trial. I'm going to set your trial relatively fast, because I understand that we can get the parties here that are necessary. Your trial will be Monday, May 19th at 9:30 a.m. There'll be a no contact order. And based on the information I received about your case, I'm going to give you a lower end bond. Normally my bonds are $10,000, 10%. But just based on the information I heard that's surrounding this case, I'm going to put you on the lower end, which is $5,000, 10%. So that's about $554 to get out. If you're able to make that bond, make sure you appear here Monday for trial. If not, that's why I set it so close. I don't want you to have to sit. So the bond is $5,000, 10%. Not guilty, no contact, and I'll see you Monday, all right? Okay, if you can scoot down. Then we have Mr. Burke, Kevin Burke, which is 14. That's also an allegation of domestic violence. That complaint states that on or about the 9th day of May, you did strike your girlfriend, Ms. Boyd, who resides with you, in the mouth with a closed fist. And you understand that's domestic violence, which again is up to a $1,000 fine and possibly 6 months in jail. You understand that? Mr. Burke, are you working currently? So how'd you find yourself in this situation?
Situation involved in me being drunk. I'm not totally admitted. I don't know. Nothing I normally do ever. I feel just horrible.
I know. Does she have a 614 number?
Yes.
Because we have a victim's advocate, Ms. Black, who has been trying to contact her, has not been successful yet. And what that means, the problem with that is, I can accept your no contest plea today. I'll still set a bond, but off until we find out what occurred from the other side, the other perspective. Because I have nothing to go on. I need to know everything is safe, that you'll be okay, that she'll be okay in the community. You understand that? Yeah, you can ask questions. Ms. Black, I see him as Ms. Black, can you had something?
I'd like to look at this number because it says it's not in service.
Thank you.
No, it's 477. 477.
I'm going to call
Ms. Black, can you one other second before you leave? And what about where are you going to go?
I'm going to go to the VA. I go to the VA and state that I have contacts that represent that place is really well. You also recommend that try to get alcohol.
Yeah, because even getting this case resolved, that's something we'll have to address. Mr. Burke, this is what I'm going to do. Couple things. Because as I mentioned, you have to understand my position. I hear your side, but I have no idea what occurred on the other side. So to protect everyone, I'm going to set your bond initially at $10,000, 10%. However, Ms. Black has the number. Once she's able to identify and contact the alleged victim, she will communicate with me as well as Ms. Hemmings, the prosecutor, and that can be adjusted at that time. Then we'll also make sure we have everything lined up to be pretty sure that you're going to go to the VA as opposed to just wandering around. That's a concern also. Hold on one second, Ms. Hemmings.
Yes, Your Honor. Before we can go to the VA, usually we have an advocate there at the VA who needs a little time in order to ascertain, referrals and housing, and that takes a few days. At least here in Cleveland.
Mr. Ivory, we're going to hear from we're going to have a conversation with my chief probation officer.
Mr. Who? And you can get him in right away?
Well, he has alcohol is an issue.
Housing. He has a housing issue. And he normally not experienced this, it took a couple of days. Okay. But
Okay, if we can work that out, that'd be fine. Still, though, we're going to still wait before we release him until he gets a restriction.
Okay.
Miss Black? We're doing all this without her here.
Yeah.
Yeah.
You need it, that's what I can find. That's what.
Okay. Yeah, we will.
Okay.
But what I'd like to do, though, sentences.
Okay.
All right. Yeah. Okay, Mr. Burke, so what's going to happen is you can have a seat. What I'm going to do, I know you want to enter a plea of no contest, and you do understand that's a first-degree misdemeanor where you could get a $1,000 fine and 6 months in jail. Is that still your desire? All right, what I'm going to do is accept your plea. I'm going to pass this for sentencing, though, so I can find out what's going on with this this young lady that was involved. So I'm going to set your sentencing preliminarily for Monday. However, we are going to get in touch with her to address the issue of bond. Right now, your bond is $10,000, 10%, but when I get more information, that will change. And we have court days, so we'll bring you back up and make those changes, but we at least have to have that contact before we do anything else. Okay, in that case, we'll probably see you Monday. I can't just take your one side of it. I mean, these are serious charges. The alternative is to just say, you know what, we'll just go ahead and give you 6 months. You know what I mean? But I don't want to do that. I mean, I'm sure there's ways to work this out. Plus, we have a connection with the VA also, so we can probably, on the housing end, that's something that we can make sure is happening lots faster for you. So that helps me too. But I at least have to have Ms. Black do the due diligence to try and contact this young lady, all right? So we'll probably call you back up this afternoon. All right, you can have a seat. Ms. Emmons? Tamika Boyd. 9:30. Yes, if you could, Ms. Black, that would be fine. Okay. All right, I understand we have some driving cases that we're going to get resolved, but we're going to do 2 felonies so that we can get our the city's detective, if Miss McCullough is prepared and ready for those. So it's a DV. You ready for the felonies? All right, so we have 2 cases that are felony cases. Gentlemen, I already read you what your basic rights are: the right to remain silent, the right to an attorney, the right to a trial. What happens is the adjustment for the felonies is that in addition to that, you actually have a right to what's called a preliminary hearing. A preliminary hearing is where the city has to put on evidence to indicate to me that a crime was committed and that you're connected to the crime, and that it's likely that you committed the crime. But they don't have to prove that you're guilty at this stage. If they can give me that information, because this is a misdemeanor court, I will then transfer this case down to the county where they will actually have the full hearing and determine the guilt and or innocence. But you have that right to the initial hearing where the city will indicate that a crime was committed and that you're connected to it. If I find that there's a good enough connection, that there's probable cause that you, or a probability that you committed the crime, it will go down to the county. So that's what the preliminary hearing is. And you also have a right to a bond. So you have the right to an attorney, you have a right to a preliminary hearing, and you have a right to a bond that I'm going to set. Keep in mind, the bonds are based on the recommendation from the detective. So I'm going to hear from the city in regard to your bonds. It's also important to know that you can waive your preliminary hearing, which means you would say, Judge, I don't want to have the hearing here. I would like the case to go ahead and move forward downtown. If you do that, we will waive the hearing for you. Those are the two options. So I'm going to call your cases. Eddie Petty. Mr. Petty is case 14 CRA 00551. Good morning, Mr. Petty. Mr. Petty, in your situation, the allegation is one count, correct, Detective? Felony of the first degree, 2907.02, the allegation is rape. The complaint states that on or about the 9th day of March 2014, you did sexually assault victim Hodges by way of digital penetration, and it is believed that that victim is 3 years old. That is a charge of rape, which is a felony of the first degree, punishable by 3 or 10 years in prison. The maximum fine would be $25,000. Now, if there's aggravating circumstances, the term of jail could be much longer, indicating the possibility of life. And I know that's why our city prosecutor stood up. So with the aggravating circumstances, that's what you're looking at, the possibility. Ms. McCullough. Okay. So, Mr. Petty, you do have a right to a preliminary hearing, and it's my understanding you are requesting that, correct, sir? All right. So what we will do is set that preliminary hearing for May 22nd. Well, I have here 2 days. So May 22nd, 2014 at 9:30 a.m. Detective, on the issue of bond.
Yes, before we have Petty, back in 47 years of age, from 58 years to second Boulevard, Cleveland. We have a 49 sexual arrest record, two possession of criminal food, drug abuse, attempted RSP, vandalism, drug trafficking, and drug possession, unauthorized use of motor vehicle, felonious assault, and harassment by an inmate. Victim, 3-year-old Xavier Hodges, blackmail, the evidence is a sexual assault kit, and an extra for $50,000
Okay, the bond will be set at $50,000 surety. Your preliminary hearing will be May 22nd at 9:30 a.m. All right? You can have a seat, sir. The next case is 14 CRA 00548, the City of East Cleveland versus Willie Collins. Mr. Collins is charged with domestic violence under Ohio Revised Code 2919.25, felony of the 4th degree. That's punishable by 6 to 18 months in prison and up to a $5,000 fine. The allegation is that you did, while you were intoxicated, threaten to stab your son and stepson with a knife, and that you also chased another individual or 2 individuals down the street with the same knife on or about the 12th day of May 2014. Ms. McCullough, Mr. Collins' desire in regard to a preliminary hearing. Mr. Collins, that's your desire? You're going to waive the hearing? That means the case will be sent to the Cuyahoga County Grand Jury for further consideration. You understand that? All right.
I have one further.
Yes, sir.
On the rest of the day, like I had this old school old table on the big wood is it got a post to the top of it.
Mm-hmm.
Now I had this chasing my son and my stepson with it, right? Now when the officers came and all this, I had the thing right there in my car, off the grip. Now he said he gonna get this out of my car, but they never go get it. And the trunk was open, and I'm telling them it's right there. It's right there in the car, but they never go get it. See, my son, misconception was when I'm saying the staff, because after we got into it, I'm getting tired now. These little dudes like Tasmanian Devil, they ain't tired, and they still coming at me. So I got the little wooden stick thing, and I got my staff a little bit. I know, but I ain't worried about all that. But I'm saying, the officer said he gonna go get the stick, but he never get it. Now I'm getting charged with, like I'm chasing him with a knife or something.
Well, Mr. Collins, what I'll tell you, right now with waiving, it will be sent to the county. However, all of that information is important. And in fact, it goes to the meat of the allegation, because you're charged with using a knife to make this type of threat. Keep in mind, right now, it's just a charge that the city has to prove one way or the other. So everything you said, though the city prosecutor heard it, it doesn't mean that that occurred the way that they're claiming it occurred. That's why you're going to enter the plea of not guilty. It'll be sent to the county. But I will say this also. We do have the detective here and the prosecutor. There have been situations where with the time that has expired or taken place, they've changed the charges. I don't know. That could happen. I don't know where they are in their area of investigation. But things could change. Ms. Simmons?
Yeah, I would like to say that he has two prior
DVs, which is why.
And so he would not even be able to come for that president.
Okay. All right. And that's another thing, Mr. Collins, just to let you know. Again, these are just allegations, but it could be, as Madam Prosecutor mentioned, because of the fact that you've had other domestic violences. Even if it's not necessarily a knife that was involved, the fact that there was another domestic violence is one of the considerations probably why they made it a felony. Ms. Hemmings indicating the number of previous convictions, wanted to make sure you understood that this actually may be a felony of the third degree, which could mean up to 5 years in prison because of the nature of violence. And that would also increase the fine at $10,000. But at this stage, what we're going to do is it's still a matter of them having to prove these allegations. The case will be sent to the county. Detective, on the issue of bond.
Where you have 40 felons that male for you, age, resident Stephen, who has a 27 cycle arrest, corruption of a minor, notice of a drug change, aggravated assault, drug possession, and domestic violence. Two victims with this case, both black males, one age 14, one age 17, also a resident of Stephen, and they're requesting a $50,000 fine.
So, Mr. Collins, what I normally do is I accept the recommendation. $50,000 surety will be the bond. The case will be sent to the county. But keep in mind, obviously I wasn't there. Based on the limited information you gave to me, it sounds like that's something that can be worked out possibly to your favor. So once you get your attorney assigned downtown, just communicate with them everything that occurred. All right. Good luck, sir. Both. We'll get you in a second. All right. Anton McCall. Mr. McCall is 14 TRD 00872. Mr. McCall, we're dealing with driving under suspension, hand-arm signals, rear view, and I believe a cracked windshield, turn signal and a cracked windshield. All this occurred on March 23rd, Euclid and Coit. You had insurance, and you're requesting a continuance so that you can get your privileges, correct? Are you going to be able to handle that by the June 18th date we've set? June 18th at 1:30 will be your new court date. There's a reminder right in front of you. That's the 4th? I'm sorry, we're going to change that to the 18th at 1 o'clock. Thank you. All right, we'll enter a plea of not guilty, and we'll see you back then, okay? Oh, you know what? Wait, the bailiff plumber give you a reminder. Jerome Bryant, Jr. 13 TRD 02200, driving under suspension, fictitious plates, no seatbelt on June 1st, 2013. It looks like, Mr. Bryant, you are interested in trying to get your license, correct? And you understand you have to get insurance also. So what I'm going to do is enter that plea of not guilty for you, reset you to also the June 18th date. That'll be your final continuance. The expectations that you come back with license and insurance on that date. Any questions, sir? All right, we'll see you then. Yes. Mm-hmm. Yes. Okay. Which one's he got? The affidavit. We don't have him talking about those things. I'll say no. Did he say what he was talking? What he had as far as that? I don't know. Okay. And then also, Mr. Hart. All right. I'll tell you that I'll be back this afternoon and see if we can get into the game because he has nowhere else to go. Yeah, because it's from Columbus. And we walk right out here else and but that's it. Fuentes. I'm going to talk to 13 TRD 01044. How are you, sir? It looks like this is a driving under suspension, expired placing a seatbelt from March 31st, 2013. And you are now ready to try and get your license, correct? And, or at least you're going to get the insurance.
Yes.
Okay, so the civil matter will keep you from getting your license.
Yes, it will.
Okay.
I was missing home. When I went to try to get job, she actually told me that I was able to work the store, get to court time. She told me I need to learn this. That's what I told her.
Yeah, because if you do that, what will happen is it'll keep you from getting an additional suspension, and you can work toward either getting your license back or some type of privileges. Yes. So at least we could do that.
That's my job.
Okay. Now I have 2 dates available. Normally I was setting the 18th of June, but I can even do one on June 4th, a lot sooner, so you can come back with your license. Which one do you prefer, sir? All right, so we'll see you June 4th at 1 p.m. That should be right on that reminder in front of you. You change them all? Okay. So just wait a second and we'll give you a new reminder.
1 o'clock?
1 o'clock. Who they're saying is they have money. Yeah. So they don't have any money. Yeah, that's what she was saying. She told us about it.
How much?
I don't know. She must black them know.
That's what I'm saying. You know it's not.
Okay.
Like, you just talking.
Right.
I didn't know that.
So you like that to be set for 9:30 a.m.? That's fine. All right, take care, sir. Tiana Powers. 14 TRD 01127. It's just for insurance. Yeah, it's just for insurance. Yeah. Yeah, sorry for continuing insurance. Ms. Powers, we have a driving under suspension, sunscreen, and it looks like there's a plate violation, expired plates, on April 3rd, 2014, Noble and Hillsdale. How are you today? You're ready to get the case resolved, and it looks like you're going to come back with insurance?
Well, I've been there twice. I turned the insurance to the front desk. She did write it on paper. I can bring it at any time.
Yeah, you need to. That's the second time I've heard that. That's definitely not our process.
On her body suit.
Okay. Okay. All right.
I mean, it's no problem. I have it. I can bring it back.
That's fine. Yeah, that's fine. It's not an issue at all. So what we'll do is get your case resolved today. If you have it, just bring it back. It looks like the plea agreement is a plea to an amended charge of failing to display. So you're not going to get the penalties from driving under suspension because you're now in a better place with your license. So it'll be failing to display, which carries no points, a lower fine. The tint is going to be nollied by the city, and you are going to enter a plea to the plate violation. Is that your understanding?
This is an ongoing situation.
Okay. 1 second.
Complaint against corruption.
Okay. Okay.
I guess you can proceed.
Yeah. So, Ms. Powers, just so we're clear exactly where we are, and I'll give you a chance to speak. It's my understanding that the license are going to be changed to failing to display, and the plate, the expired plate, we're going to have you plead to that with the tint being thrown out. And just so we're clear, the allegation is that when you were stopped on April 3rd, 2014, your plates expired March 7th, and that at that time there was a suspension by the BMV, but that you've since cleared up.
And that was incorrect. I do have paperwork, which is all together. I thought I had it grabbed the wrong folder.
Okay.
The BMV suspended my license incorrectly as well because I had insurance at that time. I simply went down there correctly.
Okay.
The only reason why I could not get my plates is because BMV had my license suspended incorrectly.
Let me ask you that, just there, where your plates were expired on March 7th?
Right.
And so by April 3rd, you had not tried to get your plates and found out that they were on hold almost a month later?
No, I was just in the process of being homeless.
Okay. Okay, all right.
I informed them. So my address of me even knowing of all of that, now my birthday came.
Okay.
It's just a hard time. I didn't have any money, but I was in constant communication with the union and everything.
Okay.
Trying to get this done.
I understand.
But I'm not, I understand I didn't have it at the time. I do understand. But since everything has been rectified.
Well, let me ask you this, because if your license, only thing we can resolve it today, but if you had paperwork from the BMV that they had done it by mistake, I mean, sometimes they actually put that on there, that may change your plea altogether, yeah. You just want to resolve it today.
No, I asked her, should I go home and get it right now?
Well, if you have it, I mean, if you have something, and I'll tell you exactly what it would have to state,
okay.
Is that on the day that you were stopped, or somewhere around that time, April 3rd, if they're indicating that the BMV, whomever they are, suspended your license in error, then that would cause, from my understanding from the city, she probably dismissed that charge. Mm-hmm. If you'd like to come back this afternoon with that, I have no problem with that. We have a docket that starts at 1:30.
That'll work.
Okay, so let's do that. Let's reset it and give you a chance to bring back your information.
Okay.
All right, we'll see you at 1:30.
Thank you.
You're welcome. Anything else other than I only have 2 more. Sir, do you have a case today? Okay. Okay. And you are, sir? Okay. Miss Austin, or Miss... He's coming back. Miss Ivory, Miss Austin, have any of you spoke with the case manager? Okay. And Miss McCullough, I think it would be beneficial for everyone to at least have a conversation with Mr. Turner's case manager. If you could step out, I'll do that real quick. And then I'm gonna, so Miss McCullough, and then Mr. Briscoe is not guilty, right? It looks like.
Unless he changes it again, yes. I don't know his family. See, his pastor and all that, so I'm gonna take a work over some cash over. Yeah, and I guess the rest of the group is in Holland.
Domestic violence, okay. All right. Is there anybody over here that I didn't take care of? I know I have Mr. Briscoe. What's your last name? Turner. What's yours? Where? Do you have Mr. Ware's file? How much